So, what do we have to prove if we're representing an employee in an ADEA reduction in force claim? So, this is basically a disparate treatment case. It could also potentially be disparate impact if you have enough employees as your clients to show percentage wise. There was a disparate impact on the older workers. But disparate treatment, basically, you have to show obviously that there was an adverse employment action, so that the employee was in fact discharged or laid off. In protected class, so 40 years or older. They were qualified to assume another position, meaning that there was, whether it was the same job or a different job, they were qualified to assume another position within the company. And then we have to have proof that the employer intended to discriminate based on age. And so that's where it gets a little bit tricky. It could be all sorts of proof. It could be something like we were talking about before with age-related comments being made, or it might be financial types of comments being made, but they're based on age. The fact that, we can get rid of one older worker and save two younger workers, which makes sense to a certain extent, but it is definitely an ADEA violation to do that. There was a case in the old textbook that we used to use in this class where the employee who brought the ADA claim testified that the supervisor made statements that they were laying off older people. The jury found the employee to be credible, and that was enough to prove that it was an ADEA violation and win the claim. So sometimes it's nice to have more than just one of the parties um, stating what the other party said, but that if credible, that witness can certainly be enough to prove the case. One thing to keep in mind, and this can be, again, a little tricky, we've talked about this in other situations. The employee who was laid off or discharged, they only have to prove that their level of performance, as it is relative to the younger coworkers, meaning they don't have to prove they were the best employee. They don't have to prove they were better than the younger employees who were retained. They just have to prove that they were qualified. So, so sometimes, especially I see this on test answers, when you're given a scenario and you're like, what does the employee have to prove? And the tendency is prove that they are more qualified than the younger employees. They don't have to prove they are more qualified. They just have to prove they are qualified for the position. So basically, as qualified as other employees. It's not a problem if they're more qualified, but that is not what is required. And if you get that into your head that that's what's required, then you're going to be evaluating these cases incorrectly. They just have to be qualified for for any remaining jobs that exist after the layoffs or the discharge. And again, if the employee can prove that the ADA decisions were based, I'm sorry, that the reduction in force decisions are based on age, or if they can prove that the entire action, the decision to do a reduction in force was prompted by the desire to get rid of older workers, that is enough to support an ADEA claim. The employer then has to be able to demonstrate that there were sound business reasons and criteria that had nothing to do with age that was in making a decision of how these layoff decisions were actually made. So the employer wants to have criteria, and again, this is different than the early retirement incentive that we were talking about before. Early retirement incentive is the employer coming to employees and saying, basically, we're going to give you a benefit, an incentive to retire early, and it's up to you whether to accept it. Okay. That's a completely different situation from the reduction in force. The reduction in force is the employer coming to the employees and saying, we are letting you go because we need to cut back financially. And that's when you get into these situations. Are the decisions motivated by age, or are there other financial business decisions? So in these cases, the employer wants to be able to come into court or into the administrative agency hearing and say, this is why we made the reduction in force decisions to begin with, because our business has decreased. other financial issues, and we had to lay off people. And then the employer has to show the criteria used to lay people off. Because if the employer just says, we got rid of everybody who was making more money than anyone else, and that happened to be all older people, that is an ADEA violation. It is age discrimination, um, disguised as a financial decision. So when employers are making these decisions, they're usually looking across the board, and they're trying to eliminate positions in different areas at different levels of skill, at different levels of experience, at different levels of tenure. And if they can show that and show that kind of broad criteria, they can defend an ADEA claim, because clearly under a reduction in force, people 40 and over are going to lose their jobs. I mean, that's just the nature of a reduction in force. Um, but as long as there are people under 40 who are employees there that also are facing the loss of jobs, then it's a much easier case for employers to make in their own defense. So again, this can result in a disparate treatment or a disparate impact claim. And what the employer wants to be able to show, especially for a disparate impact claim, that the cost reductions are necessary to avoid the company's liquidation, meaning we have to make these reductions in order to stay in business, and forcing the retirement or forcing out or firing older employees is the least detrimental alternative for reducing costs. So for a disparate impact claim, the employee is going to come in and say there was a reduction in force. It disproportionately impacted older workers. So it looks like it's neutral on its face, but it has a disparate impact on older workers, violation of the ADEA. The employer is going to have to come in to survive that claim. They're going to have to show that these types of cost reductions were necessary to keep the business in business, to keep the company in business, and that this forced retirement or firing of these older employees was the least detrimental alternative, meaning there was no other alternative that was less harmful to these employees. And that's a pretty high burden for an employer to bear. So employers really have to be careful of those disparate impact claims. Disparate treatment, probably under the reduction in force, a little bit easier to defend, because if you can show the criteria that was used, if you can show, they were not qualified for other positions, or that people that were kept were in the same protected class and were qualified, there's a lot more room there for the employer to bring a defense. Disparate impact, there's not a lot of room for an employer to bring a defense, and it's a pretty high burden for the employer. Okay, so that pretty much, last thing I wanted to mention, any sort of waiver and a reduction in force case, just like a waiver in the early retirement incentive, if the employer is having the employee sign any sort of waiver to waive rights to bring an ADEA claim, that type of thing, those also have to follow the Older Workers Benefit Protection Act. So that law has to be followed anytime you have an employee 40 and over leaving employment and signing a waiver saying that they will not sue the employer for an ADEA violation. That law has to be followed as well for a reduction in force. That's not as common to have those waivers and reduction in force. Where we always see them is in early retirement incentive. But if you do have an employer using them for reduction in force, you still have to follow the same rules and the same law, that it's voluntary. The signing is voluntary, and they have time to think about the rights that they are giving up by signing that waiver. So if you see that, the same law applies. Okay, so this pretty much finishes chapter 6. So after the break, we're going to look at some examples and see about the application and make sure we understand all these concepts. And we will also be moving into chapter 7, the Americans with Disability Act. So that is it. And again, thank you for your patience. I'm sorry for the noise in the background and constantly having to stop and restart.